America wakes up to confusion, disbelief, and breaking alerts flashing across every screen. The Supreme Court, in an emergency midnight decision, has just erased every firearm permit requirement in the country. No warning, no leaks. Just a single line in the court's order that sent the entire legal system into meltdown. The Second Amendment does not depend on government permission. Phones buzz. Newsrooms scramble. Governors call emergency meetings before sunrise. Some celebrate it as the greatest restoration of liberty in a century. Others call it a reckless gamble that will test the limits of public safety. Permit offices shut their doors. Social media feeds explode with disbelief. But this didn't start overnight. Weeks before this bombshell ruling, something unusual happened. A coalition no one expected, and a legal petition that quietly gathered the force to shake the country awake. And if you think the decision itself is shocking, wait until you hear who pushed for it and why the Department of Justice changed sides after decades of defending permit laws. Because what unfolded behind those marble walls wasn't just another case. It was a constitutional earthquake in motion. A few weeks before the chaos, something strange appeared on the Supreme Court docket. An emergency petition quietly filed under the title Patriot versus Bureaucracy. Nobody paid attention at first. It sounded like just another long-shot lawsuit, until the Department of Justice stepped in. That's right, the DOJ. The same agency that spent decades defending permit laws suddenly flipped East-West sides. And when they did, 25 states followed. Red, blue, and even a few purple ones. Texas stood shoulder to shoulder with Michigan, Florida with Pennsylvania, all demanding one thing: end firearm permits once and for all. What made it so explosive wasn't just who filed it, but the argument buried inside. They claimed permit systems violate something called the prior restraint doctrine. The same principle that says government can't make you get permission before speaking freely or practicing religion. In simple terms, if you don't need a license to print a newspaper or attend church, you shouldn't need one to carry a firearm. That single argument hit like a thunderclap inside Washington. Within days, lawmakers panicked, advocacy groups mobilized, and the case was fast-tracked under emergency review. Nobody realized it then. But that quiet filing was the first tremor of the legal earthquake that would soon crack the country in half. It happened just after midnight. Reporters were already asleep, the court's website barely holding up. And then suddenly the order dropped. No long opinions, no warning leaks. Just one bold paragraph that rewrote American gun law overnight. The justices ruled that any permit system requiring government approval for firearm ownership or carry is unconstitutional, effective immediately. Within minutes, chaos erupted. Sheriffs in California started getting calls from confused deputies. New York's permit offices were flooded with emails asking if years of waiting and fees just vanished. By sunrise, lines formed outside gun stores as people tried to understand if they were now free to carry without paperwork. The language of the ruling was clear and brutal. No state may convert a constitutional right into a licensed privilege. That one line ended more than a century of bureaucratic control. Millions of active permits instantly became meaningless, and those still waiting for approvals, automatically granted by default. But that wasn't the craziest part. The court didn't stop at striking the law down. It authorized immediate federal enforcement, federal marshals, fines, direct intervention in state offices. Something no one had ever seen before. And just as stunned governors began drafting emergency statements, another surprise landed. A name no one expected to see on the list of supporters: the Department of Justice. The Department of Justice backing this case wasn't just news, it was heresy in D.C. For decades, the DOJ fought tooth and nail to defend firearm permits. They spent millions in court arguing that permits were reasonable regulation. And now, they'd flipped the script completely, calling those same laws administrative tyranny. Their brief read like a confession letter. It admitted that permit systems had become a tool of discrimination, denying poor and minority applicants at rates up to 300% higher than wealthy zip codes. In short, the very system meant to protect citizens was quietly punishing them based on where they lived. That revelation turned the nation's political map upside down. 25 states, red, blue, and everything in between, filed supporting briefs, siding with the petitioners. Together, they represented over 60% of the U.S. population and 312 electoral votes. States like Texas and Florida expected it. But when Pennsylvania, Wisconsin, and Michigan joined in, that's when everyone realized this wasn't just a conservative rebellion. It was a constitutional reckoning. Governors started calling emergency meetings. Gun rights groups declared victory before the ink even dried. Even the White House was blindsided. The DOJ hadn't just joined the fight, they'd led it. But behind the scenes, the Supreme Court wasn't done. Because this decision didn't just end permits. It created something entirely new. A federal enforcement order that's shaking every state office in America. The morning after the ruling, something unheard of happened. U.S. Marshals were dispatched not to arrest criminals, but to stand guard inside state offices. Their orders? Simple. Stop anyone from processing, renewing, or collecting money for firearm permits. Every desk, every database, every fingerprint scanner went dark under federal watch. For the first time in American history, the Supreme Court didn't just issue a ruling, it sent in boots to make sure it was followed. Any state official caught enforcing the old permit laws now faced $10,000 fines per day and potential civil rights charges under Section 1983. The reaction was instant. California's Attorney General called it judicial overreach. New York's governor held a midnight press conference demanding federal agents leave state buildings. But the feds weren't budging. And just when things couldn't get stranger, the court dropped one more shocker: a victim compensation program. Anyone who had ever paid a permit fee, waited months for approval, or been denied could now claim damages. Automatically, over $2.3 billion was set aside from state-collected permit revenue to repay citizens for what the court called unconstitutional deprivation. Payments ranged from $500 to $50,000 per person, depending on how long they'd been forced to wait or how often they'd been denied. By the end of that week, entire state permit divisions had shut down. Offices once flooded with paperwork now sat empty, the walls lined with obsolete forms, a symbol of bureaucracy that collapsed overnight. The rebellion started within hours. California, New York, Illinois, and New Jersey all went on record refusing to comply. Governors called it a constitutional crisis. State police were ordered to continue permit checks until further notice. But the Supreme Court's response was just as swift. Non-compliant states would lose all federal law enforcement funding, FBI cooperation, DEA task forces, and federal court access for state prosecutors. That meant cases would stall, investigations would freeze, and budgets would bleed dry. New York alone stood to lose over $340 million in annual federal grants. And the warning came with teeth. Any official who knowingly enforced permit rules after the deadline could face federal prosecution and up to 10 years in prison. Years in prison for civil rights violations. Within days, state attorneys general started holding emergency sessions. Some quietly voted to suspend enforcement. Others tried to fight it in appeals court, but the message from Washington was clear. Resistance would cost more than compliance. Meanwhile, ordinary citizens were watching in disbelief. Some saw it as liberation, others as lawless chaos. One thing was certain: the fight between state sovereignty and federal authority had just entered a new, dangerous phase. And as states scrambled for loopholes, one constitutional twist appeared that could change the game entirely. Something being called the constitutional carry domino effect. When the ruling hit, lawyers called it the domino effect. Because the moment permits vanished, constitutional carry wasn't optional anymore. It became the law of the land. Overnight, every American adult who could legally own a firearm could also carry one. No permission slips, no waiting periods, no bureaucratic hurdles. 22 states that once required permits had to rewrite entire sections of their law books. Gun training facilities that thrived on mandatory certification courses were suddenly empty. State revenue from permit fees, over $400 million a year, disappeared like smoke. And the ripple effect didn't stop there. Courts began fast-tracking lawsuits challenging local restrictions on carry zones, age limits, and training mandates. Legal experts warned this could wipe out over 20,000 firearm regulations nationwide in the next 6 months. To gun owners, it was the victory of a lifetime, the end of what they saw as decades of creeping government control. But to police chiefs and city mayors, it was pure panic. Their states had just gone from regulated carry to unrestricted freedom, and no one had a plan for what came next. And while politicians screamed about safety, constitutional lawyers saw something bigger, a precedent that wasn't stopping at guns. It was about to ripple through every other right America holds sacred. The real earthquake wasn't about gun, it was about power. Because buried inside the court's opinion was a line that sent shockwaves through every corner of American law. No constitutional right shall depend on government permission, licensing, or payment. That single sentence didn't just end firearm permits, it rewrote the foundation of constitutional governance. Legal analysts called it the Heller Principle on steroids. Suddenly, every other right tethered to a government approval system was on the chopping block. Free speech permits for protests? Gone. Assembly licenses for public gatherings? Void. Even state rules requiring churches or journalists to register for activity permits were declared unconstitutional by extension. Law professors called it the Precedent Revolution. For the first time in history, the burden of proof flipped. Government now had to justify why any restriction should exist, rather than citizens begging for permission to exercise their rights. Civil liberties groups were stunned. What started as a Second Amendment battle had turned into a full-blown constitutional wildfire, one that threatened to burn through over 50,000 local and federal regulations in its path. By the time the legal dust settled, one thing was clear. This wasn't just about guns anymore. This was about redefining what freedom actually means under the American Constitution. By sunrise, America didn't look the same. Permit offices were dark. Lines of confused citizens stood outside, holding folders full of now worthless paperwork. Some cheered, others shouted. No one really knew what to do next. Gun shops were flooded, phones ringing nonstop, shelves clearing out. In rural towns, it felt like Independence Day. In cities, it felt like a ticking clock. Police departments scrambled. Chiefs ordered emergency meetings trying to rewrite carry protocols before their morning patrols hit the streets. Officers could no longer ask for a permit, which meant a routine stop now carried a new kind of uncertainty. The federal government claimed the transition would be orderly. It wasn't. States like California and New York filed last-minute appeals, arguing the court had overstepped its authority. But while the paperwork flew, the decision was already live. Every single permit law in America was now void. Newsrooms went into chaos. Cable hosts argued about whether this was freedom or anarchy. On social media, #Permitless Nation was trending by noon. Economists warned of lost revenue. Activists called it the rebirth of liberty. Both were right. And through it all, the one phrase everyone kept repeating, from the courthouse steps to the gun counters, was the same. Did that really just happen? Because for the first time in modern history, every American had full access to the Second Amendment, and nobody could predict what would happen next. And just like that, the permit era is over. One Supreme Court decision, and a century of red tape vanished overnight. Supporters call it freedom restored. Critics call it reckless. But either way, there's no going back. For the first time, the Second Amendment stands on its own. No signatures, no fees, no permission slips. The question now isn't, can you exercise your rights? It's, will the government dare to interfere again? Stay sharp, because this ruling just lit a fuse under every constitutional fight still standing. Subscribe now, and I'll keep you ahead of what comes next.